Good morning, my name is Ross Hersemann. I'm the organizer of CVGLS. I am also the founder of Loading Law, which is a law practice here in Chicago that caters to the needs of tech entrepreneurs and game developers. I'm also the chair of IGDA Chicago, and I am an adjunct professor at DePaul University. Who wants it next? Who's hungry?
I'll go next. So I'll do a different bio than I did at the beginning of my other panel. So I'm Scott Kelly. In addition to working at Banner Witcoff, I also write for the blog patentarcade.com, where we write on intellectual property issues and how they touch on video games. In addition to that, I work with Ross on the American Bar Association's intellectual property law section. They have a digital games committee, so I'm the chair and Ross is my vice chair. So if anybody's interested in getting involved with the ABA, please reach out.
Sure.
Hey everybody, my name is Liz Surette. I too have a solo law practice focused on video game clientele. I mostly work with indie game developers, but I also have a lot of other different types of businesses. I am on the steering committee for the IGDA Business and Legal SIG, so if you're interested in getting involved with IGDA or the SIG itself, we have a lot of cool benefits and we have a lot of cool stuff planned for the upcoming year. We're trying to revitalize it, so anything you have to add would be awesome, and there's information about the SIG in the other room. Disclaimer, whatever I say is not reflective of IGDA's own views. But.
Right, and then it's me again, Brandon Huffman. We're going to get to know each other pretty well over the next 2 hours, so I'll be here.
Yeah, Brandon's being a trooper. He's going to be on 3 panels today. You are a damn hero. We've already had some disclaimers today, but we have to make one more. Again, we are all giving our own opinions, not necessarily the opinions of anyone that we are affiliated with. For me, that is IGDA Chicago. For Brandon, that is IGDA proper. For everyone else on the panel, this is legal information, not legal advice. We don't have an attorney-client relationship, so please don't treat it as such. If you have specific questions, and this is going to be a very question-heavy kind of panel, come find us afterwards for your specific questions. Keep all your questions kind of relevant to the topics we're talking about today, or general, so that we don't have to know too much about your business and you don't have to know too much about ours. Walls of text. I always hate walls of text on slides. I always tell my students never to use them, but this is one of those years.
They can't see them anyway.
Perfect. Yeah. That's the best kind. Why does nothing work today? See, I had all these pretty slides to show you, and none of them work today.
It's your desktop. Are you extended instead of mirroring?
That's a good question. Aha! How many lawyers does it take to make something we can't see? Bam. Okay, so I can click. See that now it's not even over there. So here are all of the slides that we had before. Why are we on an extended desktop? It wasn't like this before.
Are you in PDF and we were in PowerPoint before?
That might be it, actually. But oh man, this is so much pressure. Everyone is watching me do this in real time.
Good now.
Haha! Success. Okay, it's still in potato P, but at least it's where it needs to be. All right, take 2. Walls of text. I always tell my students never to put walls of text on slides, but there's so much going on this year that this seemed like an appropriate way to do it. There are so many issues that we can address just this year. We've talked about loot boxes today, we've talked about free speech already, we've talked about data privacy and patent work. All of that is always developing and evolving all the time. But here is some of the litigation and landmark decisions that came out this year. And one of the ones that I'm very interested in is Iron Maiden versus Ion Maiden. There's been a trademark dispute going on, and we have an actual metal lawyer in residence here. So Liz, what can you tell us about Iron Maiden?
No, I thought you never mentioned that aspect in my bio, but yes, I am the resident lawyer, metalhead in the legal profession, so I was very interested in the Iron Maiden case. So the publisher 3D Realms published a game that was originally called Ion Maiden. It is now, spoiler alert, Ion Fury. Long story short, Iron Maiden hammered them into the ground, and they agreed to change the name and settle. But leading up to that, the developer, whose name escapes me at the moment, they were making Ion Maiden. They filed to register a trademark for Ion Maiden with the PTO under International Class 9, which covers video games. And Iron Maiden, the band, caught wind of that and sent them a C&D to immediately cease and desist all uses of the name Ion Maiden, not just the application. So 3D Realms did withdraw the trademark application, but they did not stop using the name. And so Iron Maiden sued. And they made a number of legal arguments that are now moot, but they did argue that Iron Maiden is a famous trademark, which along the lines of Google or Coca-Cola, something that is just so well known that they get protection for all of the classes of goods, even if they're not registered in there. It's kind of a moot point. I would have loved to see that litigated, to see what a court would say. But anyways, what game developers can learn from that? I know a lot of people are gung-ho about, the big companies bullying the small developer, but even if you don't think somebody has a case, I know trademark trolls exist. For all the developers in the room, you do want to take it seriously. If you get a cease and desist letter, you don't want to end up having to pay a lawyer to file an answer for you in court or anything like that, only to have to settle out anyway. So have a thorough trademark search done, just to see that, make sure that you don't come up against any marks that are similar to yours. And also be mindful of your dealings with your publisher, because your publisher is going to have something in their agreements that say nothing you give to them is going to infringe on anybody else's rights. And again, you do want to take it seriously, even if you think they're some kind of trademark troll, or if you don't think it's personally fair that they're coming after you, you still want to talk about it with a trademark lawyer. And also, the whole famous mark argument is moot anyway, because Iron Maiden did get a registered trademark for video games in August. That's when it registered.
See, now when I think of Iron Maiden, I obviously think of a famous 80s heavy metal band, but I don't always necessarily think video games. Like, what dog do they have in that fight? Do they have any experience with video games? Or like, it seemed like it was out of the field.
Oh, they have Legacy of the Beast, which is a mobile game. It was the theme of the tour that I attended twice this year, which is very good. They have the Iron Maiden pinball machine, which I played. It's also very good. It had one game in the 90s, Ed Hunter, and I think something else, right?
I think there was another one in the early 90s around Ed Hunter.
Right, so they've had a few, but they've also they make everything. They make lunch boxes, they make coffee mugs, they make t-shirts, to which I have. They do all kinds of things. Whether or not they're a famous mark, we will never know. But there could be an argument made either way, I think.
Well, how many people in the crowd have heard of Iron Maiden before today?
Yeah.
That's pretty good odds for a lot of lawyers and game developers.
How many people had heard of the torture device but not the band?
We got at least one.
We got
that's
one.
good enough.
Yeah.
So
that case probably ended up right. Yeah.
I think
Right.
so. I think that came out the way that it should.
So a few of the factors that the band alleged caused the infringement were the steel-cut font in the Iron Maiden logo, and also the sight-sounding meaning of the words Iron Maiden. There's only one letter that separates Iron Maiden from Iron Maiden. And they did look at game content, but only insofar as to look to 3D Realms' intention, like whether they purposely intended to cause confusion between themselves and Iron Maiden. So a lot of the news coverage on this was really wrong. A lot of the news coverage said, oh, well, the game content has nothing to do with anything of the band. Well, the game content is only being looked at for intent. It's not being looked at as part of the, as one of the factors to prove intent to confuse, or it is for intent to confuse, but it's not a copyright issue, I should say, content issue.
Oh, sorry. Yeah, so I mean, one of the things that I think is a useful takeaway for this case is just think about, why did they call the game Iron Maiden? I mean, if you look at the game and it was all about a female, I don't know, atom that lost an electron or something, maybe, but I mean, it seems kind of clear that, the similarity was intentional, and that becomes in trademarks the idea of sort of, trying to free ride on somebody else's goodwill. So, I mean, it's one of those areas where it feels a little bit like, hey, just let them have their fun, but you have to look at, what were they doing here? Why did they do this? And yeah, I mean, I think it speaks to that idea of intent. And, whether or not there were a lot of debate over, is somebody going to think they endorsed the game or it's their game or that sort of thing. That always comes up in trademarks. I don't know that they were really trying to sound like Iron Maiden had blessed their game, but they were clearly kind of trying to play on that common cultural sense that people could kind of relate to. So that's what stood out to me here.
Yeah, and to that point, it's also possible that this was the intended result all along,
Publicity, yeah.
So this has happened before, right? So and I'm not saying that this was intentional when they did it, but there was a game company, or is a game company, that was formerly known as Squanch Tendo. Now is known as Squanch Games, right? I'm pretty confident they were aware of Nintendo, and I think that they knew that Nintendo would not be happy with that, but they chose to name their company that anyway. And maybe they did it so that people would go, hey, look at this story about this game company, that this stupid trademark thing. But if you take off that last part, it's, hey, everybody, look at this game company, right? You wouldn't have done that but for that. So I wouldn't suggest that as a strategy, but it could have been the strategy.
Definitely. I think there's been a couple cases this year that kind of piggyback off of that notion where you wonder, how could they have not known? This must have been intentional. There's a new one with Riot, which is actually on my last slide, but there's what was the new one? Because there's Riot Games, and then there's it's an esports team, right? That was trading off of the Riot name, but they had a very similar logo there that was coming up, and it's one of those things where you can look at it and say, this is intentional, and that factors into trademark. But for a bit of a segue to another topic, what about when it's not intentional, or what about when it's more questionable in the realm of copyright, Fortnite dances? How many people know about the Carlton dance? This was another really big topic this year. Everyone was asking during the lunch break, like, what's the hot topic of this year? I've gotten the most questions about the Carlton dance and copyright issues than I think anything else. But the makers of Fortnite include a lot of emotes in their game, and a lot of those are dance moves, and a lot of those dance moves are very recognizable. The man who kind of put forth the dance, known as the Carlton dance to most people, brought a suit against the makers of Fortnite, claiming that he had a copyright interest in that dance move, that he'd been doing it for years, and that this was his product that they were now leeching off of. In an interesting move, while that case was still getting legs, the Copyright Office kind of took it upon itself to weigh in and kind of pen a letter saying, actually, you can't copyright a dance move that's that simple. There is a copyright precedent for more extravagant dance steps, entire dance routines, Broadway plays, far more content. But for something short, simple, the hustle, the electric slide, the Carlton dance, dabbing, these things were, determined by the Copyright Office not to have enough content in them to be copyrightable. Do you all think that came out the right way, or should it have been the other way around?
So I have an opinion on this one. So Epic is right in my backyard in Raleigh, and all of the Epic issues outside of this, right? Like, let's ignore that this was Epic for a second. They obviously knew that they were pulling the dance from something that people were going to look at it and go, hey, that's the Carlton dance, right? That being said, if it's not copyrightable, it doesn't matter from a copyright perspective. I think the most interesting part of this case to me is that this case, alongside the 2 Milli and the Flossie Kid and all of the other dance cases that came out at the same time, is that it was one law firm that filed all those cases. And the complaints were almost mirror images of each other. And then once that copyright opinion came out, they just kind of backed away from the whole thing. And there was a different level of merit to each one of those cases, but the law firm just kind of gave up, it seems like. And so that's interesting for a couple of reasons. The legal reason it's interesting is that I think there was a better argument for a right of publicity claim in the Alfonso Ribeiro case, specifically because I don't even know that he owns the copyright in that dance move, right?
I don't think he does.
Like, that's probably whatever publishing company or whatever production company made Fresh Prince originally. It's probably not him that even owns the copyright in that. So, but you look at it and you go, oh, that's Carlton. And I think the publicity difficulty is, do you then make the leap and go, Carlton is Alfonso Ribeiro? I don't know. But I think that would have been a better argument to make. It just would have taken more time and effort, and the law firm obviously, or Alfonso Ribeiro himself maybe, didn't want to go through that, and so the case just kind of went away. But that would have been an interesting claim, I think.
I agree, and I think that dance move is really iconic to him, but he's not the only one to have ever done that dance move before. Bruce Springsteen did something very similar in Dancing in the Dark, and Tom Jones had a move that was virtually identical to that decades before.
And arguably it's based on the Tom Jones one, because the whole thing is set to the Tom Jones song in Fresh Prince, right?
Exactly, and Alfonso doesn't own that, so it was kind of a bold move. It was a weird flex on his part.
Yeah, I mean, did a little bit of reading up earlier. I mean, I'm not sure that the cases are gone and dead, right? They were dismissed after Fourth Estate. The Supreme Court weighed in and said, yeah, everybody knows you need to have a copyright before you bring one of these lawsuits, but what if you get denied? Okay, well, you have to have actually applied, and you have to hear back, either good or bad. You can't file a copyright lawsuit until you have this. So, I mean, that decision came out, and within like a week, they had pulled all the lawsuits. What I thought was really interesting about that is they had already been denied on some of them, and they still withdrew it. That case stood for you can still pursue it. So they clearly did have second thoughts. I mean, it's a great point that it was all filed by the same firm. I mean, it absolutely reads like a creative lawyer had a really good idea one night and was like, oh man, Fortnite is making so much money. What if I could just do this and go out and so, yeah, I mean, it was a fun one to watch, and it got the whole community really excited. I think it had the potential to really change things and be a big deal, but I think odds have pointed to it's not going to be a thing.
Yeah, and this is the legal lesson here is to know your opponent, because Epic is not a company known for backing down from those kinds of challenges. They have taken litigation all the way through trial. They have won that litigation. They have bankrupted companies in doing it, and they're not afraid to do it again. So you gotta kind of know if you're gonna try to like get an easy settlement out of a rich company, is it the kind of company that's going to pay you an easy settlement, right?
No, that's a really good takeaway. I agree. You always have to know who you're fighting. And that's actually a really good segue for another point we have on this slide, which was another port of Mario. A gentleman made a almost picture-perfect port of the original Super Mario Brothers for the Commodore 64, which for some of the folks in the room who may not have been there, was a amazing gaming PC back in the 80s. And he got the typical Nintendo treatment. Nintendo came after him, sent him the DMCA, and that's all she wrote. And it's one of those things where I know everyone else on the panel, it always gets these fair use questions, always gets these, well, it's a really old game, isn't it fine? I have to answer a fair use or a DMCA kind of question almost every week from clients who want to make a sequel to a game or a reboot or a port. Do you see any signs of this kind of thing ending? Are people ever going to wise up, or are we just going to see port after port after port and more DMCAs?
I don't think so. You take, for example, there was a game a couple of years ago called Pokemon Uranium, and those developers put so much work into it. They made their own original Pokemon, made their own original world, and they just did all this stuff. It was a passion project, which I understand as a human. Like at PAX, I very rarely put my human hat on, but I do understand it. I do understand that you care about the IP, but all of that work, at the end of the day, was for nothing because Nintendo found out about it and issued a C&D for a takedown notice for copyright and trademark infringement, and they had to take it down or else face the wrath of this enormous company. So unfortunately, if people didn't learn after that sort of thing, or after the Metroid one, or after the Duke Nukem one, I don't know if they'll ever learn.
I saw another one based on Doom recently, and then just this last summer there was a fantastic fan game based on Spyro the Dragon that looked picture perfect, and that's one of my favorite game franchises, and I'm a game lawyer, and I looked at that fan game and I was like, oh man, they made another Spyro game. No, they didn't. So if I was confused, I'm pretty sure everyone was confused.
Yeah, I mean, I don't see them going away. The passion is great, and one of the challenges for a lot of game companies in kind of adapting to the internet era is how to sort of engage with that passion. You want your fans to be passionate about your game. You want you can benefit from having a meme around your game or that sort of thing. But it's also about kind of governing it. And when you're on the smaller side, or when you're a fan and you look at this and it's like, man, that really sucks. Pokemon Uranium was supposed to be really fun. Try to put yourself in the other shoes. If you had yourself made like a really hit game with a popular character, and you made some money off of it, and then somebody else came around and sort of started free riding on that. They made a sequel. They made another story about your character, and then they made a lot of money. Wouldn't you kind of feel like you deserved a little bit of that?
Just a little bit.
And wouldn't you feel like also they might not be handling your brand name correctly? I mean, your brand name carries your reputation and your goodwill, so if someone is using it, I mean, you don't know what kind of damage that they would do with it if you allowed that to happen.
Yeah, or they stop you from doing something that you could do in the future. If somebody already told the story of how your character got their iconic blue hat or something, you can't make that prequel. Or you could, and then it's going to be compared to the fan game that you had run amok. So.
Yeah, like the question always comes to derivative works, and it's not just a sequel or a reboot or a port. Sometimes it's an expansion or an add-on or a completely new feature. Pokemon Go has kind of been stomping a lot of apps into the ground for people who are making add-ons for Pokemon Go. A lot of different websites or data tracking for these apps for Pokemon Go. Things that showed where Pokemon would spawn, or things that you could use that were accents to the game that maybe Niantic wanted to include down the line but couldn't because they didn't have the development time. And that falls under that same purview of, don't make things that you don't own.
And I think another point here is when you put that much effort into this, I mean, part of why we have the intellectual properties that we do is to encourage ideas and creativity and new things to flourish. So, the incentive under the law is kind of go make something new. And so if you put that effort into for creating something new, we could have something even better. So, yeah.
I agree. Let's see, segues. We have so many issues today. We are not getting to all of these. One that I want to hop into that just came out this week that's going to be very interesting, and this dovetails a little bit off of some of the free speech that you were talking about on your earlier panel. Microsoft is rolling out a new feature for Xbox Live, maybe not right now, but in the near or soon-to-be near future, where they could potentially auto-bleep any swears or objectionable content in real time over their live network. So if you're in the middle of a death match with someone on Call of Duty or Halo and you start swearing or you start throwing out ethnic slurs or anything else, Xbox is listening and they're going to be censoring you in real time. Microsoft has kind of touted this as a response to all of the issues of harassment in its online network, and they're trying to be sensitive to their user base and create a more inclusive, happy, safe environment for folks. At the same time, a lot of folks on the internet are crying foul for censorship. This is going to be coming down hard on words that they want to use or that in a particular context or nuance they might have a right to say or not say. How does this fall into free speech protections or not?
It doesn't. Yeah. So Microsoft is not the government. Microsoft has lots of government contracts, to Mark's point, that the government could theoretically say, hey, we're going to predicate funding on you abiding by First Amendment and doing this, but the government's not going to do that with Microsoft. The type of relationship Microsoft has with the government is not a grant. It's not, they're not a university type, like Title IX situation. They are a private actor that contracts with the government for a direct commercial relationship, so the First Amendment doesn't apply to them. They can censor what they want in their platform. I'm a big First Amendment advocate, if that wasn't already clear, and I'm totally stoked for this. I can play my Xbox with my kid in the room, in theory maybe. We'll see. I don't think it's going to work as well as they hope it will. And honestly, I've avoided multiplayer games on Xbox for exactly this reason. I'm not that good at a lot of games. And 13-year-olds shouting horrible things at me makes me feel bad about myself. So I'm really excited for this.
I agree. I think there's a lot of cool things about it. I'm interested to see if it will apply to private chats as well. So if you instigate like a private chat with your friends and you're playing a game together over a LAN network, if this software is going to apply to your private conversation with your friend in the room, or if it's just going to apply, blanket to everyone playing online generally.
Yeah. I mean, we could spend 2 hours talking or more talking about the potential implications of the slippery slope argument, right? Like, oh, now they're banning the F-bomb, but in the future, what if they ban, negative speech about China or something along those lines, right? Mm-hmm. And that is theoretically possible. I think we cross that bridge when we get to it, and if we're mad about it, we boycott it, right? But I don't think we're there yet, and I don't think prohibiting people from shouting slurs at other people on your private chat platform is a problem.
Wouldn't they have to it has to be a little bit predictive because there has to be some kind of delay almost in when you say it and then when they censor it, because even things that are typed, it's not automatically censored. Like, you could see it for a split second prior to any kind of censorship being applied. So wouldn't there have to be some kind of delay feature when you hear people?
It's predictive, yeah.
Yeah, so if I say, you're a bad mother...
It's gonna, yeah. So
no one said shut your mouth.
So it uses, so it's a combination of different AI tools. I'm sure they have a patent on it, frankly, but it's a combination of different AI tools. It's natural language processing, it's predictive analytics, it's a lot of different tools that lead them to be able to do this. Interestingly, Epic is using similar technology so that your characters' mouths in Fortnite will move the same way you're speaking, and that also has to be predictive because the graphics have to render. So yeah, so a lot of companies are working on it.
This cuts a little to what we were talking about on the patent panel about, VR is a thing now because it's working. The technology has caught up. I mean, speech recognition, NLP, that sort of thing, has gotten so fast. I mean, what you're saying goes through Microsoft servers anyway. So the fact that the technology is there, they can process it so fast. I mean, there is already delay in the things that you say on Xbox Live because it has to go to space and back. So doing some processing at one point there is only going to add a little bit. So, but one thing that I think is really interesting about this one, and I mentioned to you guys earlier, yes, maybe the free speech issues aren't there because Microsoft can do what they want, but you can't help but think there's going to be some privacy issues. And one of the things that's interesting to me is somebody who, I'm an intellectual property lawyer first, I'm a patent lawyer first, and then games are an area that I work in. But for somebody who really wants to work in the legal world around video games, the just myriad of issues that game companies encounter, besides copyrights and trademarks and patents and everything, privacy is an enormous issue for video games. I mean, that's why we had a panel this morning, and I mean, I think since its current issues in games, I mean, I think privacy is probably the biggest area of law, in gaming right now.
Definitely. And if you have a predictive text, if you have something that's always listening, I remember how angry people were when Xbox One showed off its always on feature, just the entire notion of your Xbox is on and your Kinect is on and it's listening just for when you want to say Xbox on. What else is it hearing? People are very sensitive about their privacy, and we're still coming up with ways to protect that and kind of meet those expectations, but also deliver the best technology that people want.
There's also the question of to what extent would Microsoft allow the government to subpoena that if it was being recorded for purposes of processing the language? And I think we saw that with Apple and with Amazon Echo.
That's actually a pretty good segue when we're talking about privacy, is this ESA data leak that just happened with E3. It wasn't a data leak in the traditional sense that a lot of people might be familiar with people losing their bank cards or credit card information by doing business at Target or somewhere else. But it was something as simple as E3 had collected a lot of information from journalists who were going to be featured at E3 when they signed up for their press badges. They had given them their names, their email addresses, their physical addresses, phone numbers, some kind of personally identifiable information. And the folks behind E3 did not take the proper safeguards to ensure that that information was kept secret, kept safe, Gandalf style, and a lot of that information got out, and not just for 1 year, but for several conferences back. And it's kind of opened this conversation about what information needs to be private, and in this context, a lot of this information is like publicly findable information. Your address or your phone number, things you might be able to find in the yellow pages, but in a particular context of folks who often have a target on their backs.
The yellow pages used to be a book that showed up on your front door and listed people's names and addresses.
Thank you.
Went into the trash can.
What do you do when this quote-unquote private information isn't really private? It's public information, but in a particular context of folks who are always under media scrutiny or have to deal with a lot of nasty people on the internet. What precautions are there and what could have been done or what should be done? This is still a developing thing. I still haven't heard a PS on how they're going to try and put the genie back in the bottle. But it's just one of those things that we always have to worry about. I don't know. Any thoughts?
There are lawyers for that. I mean, it's a whole branch of the law, data breaches and that sort of thing. So, and to my last point, I mean, I think it highlights how there's so many aspects of law that touch game companies and thinking about, we just want to have a conference to talk about the games that we're making, but we also have to be keeping track of all this and then deal with the fallout. Game companies have all the same issues as other companies, and then a whole lot more of their own.
So one of the interesting things, so this is not, I'm not going to comment on whether ESA did or did not do anything wrong or whether it was publicly available information or not, but if it was not publicly available information, one of the interesting questions that situation raised in my mind was whether the journalists who initially published the link to the information should have done that, or if they should have just reported that it was available. Because arguably the real breach of privacy, like nobody knew it existed until these journalists put it out in public, right? So there was a way to approach that story differently that I think could have minimized the damage to the individuals, and that's not how it was handled. Now, I don't know if that creates any legal liability for the journalists in addition to ESA, if there is legal liability at all. I don't know, but it's an interesting question, I think.
Yeah, it's kind of a catch-22. By shining a light on it to try and fix the problem, they kind of exacerbated the problem.
So there was a way to shine a light on something without pointing out exactly where to find it, right?
Mm-hmm.
Traditional journalism has done this for years when they talk about things like terrorist attacks, right? They talk about this is what happened. They don't say, here's how you can do it too, right?
Yeah.
Absolutely. I've picked a lot of topics off of our slides here, but I want to kind of open it up to the rest of the panel. Were there any things on any of our slides that you're particularly hungry about or you have a stance on? A general musing that you want to share before I open it up to general questions?
I'll jump in with a quick patent one. One of the things missing from the slides is a lot of patent activity and patent lawsuits, and I think at least in 2019, while it might be a little bit indicative of how often patents come up in the industry, it's also a result of the fact that patent lawsuits are increasingly being knocked out very early on the idea of validity stage and that sort of thing. So we have this new process. Well, it's not new anymore. It's 2014 or 2013, called inter partes reviews, where you can drag patents back to the patent office and sort of re-argue, hey, this never should have been granted in the first place. Somebody already did it. And so we've been seeing a lot of activity in the video game market on the IPR front. Activision Blizzard has made probably 4 appellate court precedents just in the last year and a half, and I think a big part of that is that their name starts with A, and they're in this lawsuit with 10 other game companies. But it's been a really interesting area to watch, because as software people, and I mean games are software, there has been a little bit of a patent problem for the last 10 years. Everybody here has heard of patent trolls. You come around with kind of a bad patent, but hey, maybe I'll get a settlement out of this. Maybe we don't need to go the distance. Do you really want to pay $500K to prove that my patent is invalid, or do you want to pay me to go away? And so I think IPRs are something that just the entire patent side of the industry, it's really changed that game. And so, I mean, the big one this year was Activision versus Game and Technology. It was a patent that was asserted against Diablo 3 and World of Warcraft and League of Legends and everything. And they fought that all the way. It got some really interesting decisions where judges were debating whether or not throwing potions were consumables with limited use, which is not a legal argument I ever expected to encounter. And so, yeah, it's just been a really interesting development in the industry, and I think it's helped drive down the cost of doing business, because when patent issues get involved, it does get expensive fast. So this has helped there.
Liz, any hot takes on any other subjects?
Yeah, so I heard it said once that the most fun you can have practicing law is with trademarks. My trademarks professor said that, so he might have been a little bit biased. But in my experience, it's true. I love trademarks. It's more of an art than a science, and I love that aspect of it. So there are a couple of there's 2 companion cases that are fairly recent that have to do with what sort of trademarks you can register. And the first case involved a band called the Slants, which was a group of Asians who, they tried to get the registered trademark for the Slants. The PTO denied it, saying that it was derogatory. As part of the Lanham Act is that you can't have trademarks that were derogatory, immoral, scandalous. So, end of the day, the Supreme Court said, well, the term derogatory is very broad. It's very subjective what is derogatory. So the PTO can now no longer deny registration on that basis alone. The second case is Iancu v. Brunetti, which has to do with scandalous or immoral trademarks. So there is a clothing company called FUCKed, which is an acronym for Friends You Can't Trust. So they tried to... Supposedly, yeah. They tried to get a registration, and that was denied on the grounds that it was immoral or scandalous, and that went up to the Supreme Court, who also struck down those provisions for similar reasons. And I was thinking about it when I was doing my prep for this panel, and I thought, okay, well, there's more latitude for what kind of game titles or studio names you can register now. But then I thought about it a little more, and it's sort of a practical matter. could name your and also like the lifting of the restrictions has made my trademark searches a little more interesting. Let me tell you, you could name your game or your studio something obscene or vulgar or derogatory. There's nothing stopping you from getting the registration unless you're confusingly similar to somebody else. Just FYI, the ESRB might not rate you, and the company might go ballistic. So there is a little more wiggle room, but keep those things in mind.
See, it sounds like such a good idea. You could trademark anything now, it seems. But I see it being more of a problem at the local issue, because if you give your company or your business an obscene, vulgar name, you might be able to get a trademark on it, but that doesn't necessarily mean you'll be able to have a sign in a local town with that word in front of everyone for everyone to see, or vinyl wrap your van with that name,
Right.
drive around everywhere without any kind of problem. Like, no one's gonna look at it and be like, oh, I also saw the Supreme Court decision. Good for you. I think it's gonna be a hot mess.
Well, so interestingly, like, you probably can put that sign up now. And you probably can wrap your vehicle in it now. And if the government tries to crack down on you for it, then you have a First Amendment argument, right?
That's true.
Because, as long as your sign is the right shape, size, and color that's allowed, so if you have that issue and you name your game studio something and your local government comes after you on First Amendment grounds, please reach out to me and I'll find you a local First Amendment lawyer to represent you, because that's a fun case for them.
I think you're going to be really busy, because I see a lot of local legislation being written around that, because people coming home from church don't want to see certain words on their out on the street.
Tough.
I agree. It's going to happen.
But I think it comes back to it. Just because you can doesn't mean you should.
I don't think your company will do very well if you name it something horrible, right?
So while you can trademark your name, whatever you want, if you don't get an ESRB rating, you're not going to get stocked in any stores, and no parents are going to want to buy your game and all of that thing. So, yeah, they were predicting this enormous flood of just every curse word out there applying to everything, and it didn't really happen.
Well, there was a little bit of a flood, but it was mostly for T-shirts and hats.
Yeah.
With vulgar things.
Yeah, I've seen a lot of them for marijuana dispensaries as
that
well,
makes
and folks are coming up with very creative terms. So we'll see what happens with that. But Brandon, did you have any other topics you wanted to jump into before we open it up?
I think one of the more interesting cases of the year is the Red Dead Redemption Pinkerton Detective Agency situation. Mm-hmm. So that was a situation where Red Dead Redemption included, so Red Dead Redemption is loosely set in the Old West, right? And it has a whole lot of accurate historical references, and then it has a whole lot of fictional plot. And they used a reference to this company, the Pinkerton Detective Agency, which was an agency back in the Old West that may or may not have done some fast and loose things with morality or the law. We don't know for sure, right? But if you've ever watched Deadwood, they also reference it there. Like, this is it's a cultural thing that everybody sort of associates with the Old West. The Pinkerton Detective Agency, because it still exists, didn't really like the way they were being portrayed in Red Dead Redemption, so they sued. That case did not get resolved by the court. That case settled. But I think that's an interesting case for a couple of reasons. One is that, they were referring to the real company, and they were referring, one hopes, to things that company actually did historically, so that they weren't going to, run afoul of like defamation or something like that. But the company still sued, and the defendant still settled because they knew it was going to be a fight over whether they had the right to do that. And so I think there's a lesson in there for indie developers, which is if you name real things, there's a likelihood that those real companies might come after you, even if they don't have the right to. But the other issue, I think, is that long term, as games get more realistic, as VR and AR try to replicate the real world more accurately, as AR layers on top of the real world, there's going to be this whole issue of how and when can you refer to a real company or a real brand accurately, right? And that, I think, will be an interesting thing that comes up over the next couple of years.
I agree. I think that's a good segue to open it up to general questions. Is there anything that we've covered so far that anyone else is hungry about? I saw your hand first.
You made the reference to the real world, and I think Microsoft's new flight simulator game, where they're encompassing the entirety of the planet, immediately raises that question. And I was wondering what your thoughts are on
Yeah, and I think Microsoft is a big enough company and they're smart enough that they've probably removed some things from the real world in their map of the real world, right? There are companies that will assert either trademark or copyright or other certain rights around the world on things like the Eiffel Tower or the Hollywood sign. And so I imagine Microsoft has modified or removed those things in a way that makes them not accurate to the originals. I don't know that for sure. Or they've gotten permission from those companies maybe. Or they're willing to take the risk because they have the money to bury them, right? It could go either way.
Other questions?
So you've made a lot of mention to like things like defamation, derivative works that are even like lovingly made, fan-made creations and things of that nature. But where does kind of the line get drawn or the acceptability become available like in parody work? Like if, for example, the Iron Maiden, if it had been specifically a parody of Iron Maiden, where does that fall into acceptable versus still against?
Oh, that is a
So-
can of worms.
Yeah, parody, the concept of parody is often used overbroad in the colloquial sense. Parody is a defense to copyright infringement, or so, and the Iron Maiden case was about trademarks. It wasn't about copyright anyway. So there is a kind of trademark fair use, but it wouldn't be at play here. It's called nominative fair use. So Stephen King mentions, oh, somebody drank a Coke in one of his books. That's nominative fair use. Parody in the copyright sense, though, what you're doing has to make a statement about the original work. It can't just be, oh, I like Bart Simpson, so I'm going to put him in my game and have him do some things and call it a parody to protect myself. It has to be making some kind of comment, some criticism, something like that. And it's a very... I never recommend to my clients, like, oh yeah, go for it. So it's something... I'm so emphatic about it, you know, it's... So yeah, it's a very messy, complicated thing. I don't have a simple answer, but it's not a magic bullet. I'll just tell you that much.
Yeah, you have to already be in court to make that claim to begin with. If you're talking fair use, satire, parody, you already have to be in court. You've already said, yes, I infringed, but it's okay. At that point, you don't want to be at that point. You've already spent a lot of money, and for your average indie developer, that's money that they don't have. So just don't.
Yeah, so I worry a little bit that whenever we have lawyers saying things like just don't, that people take that too seriously. And I say that, I'm not saying go out and infringe other people's work. That's not what I'm saying. What I'm saying is understand what risks you're taking. So if you want to try to do something that involves a fair use argument, talk to a lawyer, or at minimum read a book on fair use and like understand why you're taking the risk and if it's worth it.
Other questions? I see a hand in the back.
Nate Flitter. Question. Can you give an example of a parody in video games that you'd like to give people as an example of here's a good use, a correct use of parody in the video game?
Ooh, that's a good question. So the question was, is there a good example of parody or
So
satire?
I'll give an example I think is defensible, that I think would win if they ever got challenged, and I don't know that they ever have been, but Broforce.
Mm-hmm.
I think Broforce, for those of you that aren't familiar, every character in Broforce is at least somewhat referential, if not very referential, to some character in an action movie. And they're very recognizable, but I think the whole game is silly enough and pokes fun at the broiness of action movies just enough that I think it would pass, but I can't say for sure that it would, right?
Yeah, that's a good example. One that I usually look at, and I don't know if this has ever come up, but the Angry Video Game Nerd game makes a lot of references to other video games themselves, not just in aesthetics from an art perspective, but also mechanics and audio as well. And that's one that just really is off the deep end of silly, so it would probably do well.
Yeah, importantly though, it's not that the game itself is silly, it's that the game pokes fun back at the thing it's parodying.
Yes, no, that's a good distinction. Yeah. Okay, other questions?
Was there one you were hoping we'd say?
So the number of trademark applications has risen dramatically incentive to individuals who actually obtain a trademark, and people are using, there's a lot of fraudulent efforts to obtain trademarks that are coming out of that, but just generally on the rise. And then I also know that a lot of companies have had issues obtaining what they consider to be a relevant, good trademark, that kind of, because just so many names are taken, especially in today's marketplace where it's easy to create something. Have you heard any sort of pushback on that? Like, because I have not heard about anyone having additional troubles. I haven't heard about a huge slowdown in the trademark applications, but just with the numbers, they're either handling it very well, or I'm just not hearing it.
I haven't heard of any pushback.
So there has been some pushback. I'm not specifically sure about the first part of your question, but there has been some pushback to the volume of trademarks, which is that now, in order to register a trademark on behalf of someone else, you have to have a U.S. licensed attorney, and that U.S. licensed attorney actually has to put in their bar number and be verifiably licensed. But I think that that's the only thing that I'm aware of.
Yeah, that issue actually just got written up in Law 360 today. Director Yanku at the Patent and Trademark Office was the U.S. practitioner rule has already drastically curbed that activity. But yeah, the issue that you're speaking of with sort of foreign trademark applications, it was a lot of perhaps fraudulent or negligible uses. A lot of it was just to sort of game Amazon takedowns and that sort of thing. So yeah, it really was kind of a plague on the community, and the Patent Office responded, I think, quite quickly. So I think that's going to help address some of that. And you raise a really interesting point about kind of the exhaustion of available trademarks. We saw that I mean, I can't speak to, I think there's still lots of cool names for video games around. We've actually seen that in beer. Pretty much every beer pun out there is somebody's trademark at this point. So every beer flavor, or every beer you put out, you go get a trademark on that. It has whatever beer pun or something else, and yeah. So we've seen a lot of trouble in the microbrew space of kind of coming up with new names that nobody has already trademarked.
Any other questions? All right. Well, thank you for your time.
Thank you.